appeal is Franses Limited and the Cavendish House Hotel.
Yes, Cecilia.
My ladies, my lords, good morning. I appear with Mr Faulkner for the appellant and Mr Featherstone Hall Queen's Counsel appears with Mr Taggart for the respondent. This case concerns Part 2 of the Landlord and Tenant Act 1954.
It's usually council who do that.
It is usually council who do that. I'm glad to say I'm not alone in...
It's your computer, right?
Yeah. I'm very sorry, Miss Wynne.
It's a pleasure to all of us to find that Supreme Court justices are human too.
Yes. Yes. And on camera. Never mind. I think you can carry on now. I think we're
Yes.
sufficiently over the crisis.
As I was saying, the case concerns Part 2 of the Landlord and Tenant Act 1954, by which business tenants are given security of tenure, including the right to renew their leases at a market rent. In particular, it concerns Section 30, subsection 1, little f, ground F, which gives the landlord a ground on which to oppose the grant of a new tenancy on the basis that it intends to redevelop the holding occupied by the tenant. The issue on this appeal is whether a landlord can succeed on ground F with a scheme of works which has been designed solely for the purpose of opposing the tenant's right to renew its tenancy and which the landlord would not carry out if it obtained vacant possession otherwise than ground F. We put forward two alternative bases for saying that a landlord cannot successfully oppose a new tenancy in those circumstances. First, it is our case that when Parliament refers in ground F to demolition, reconstruction or construction, it means demolition, reconstruction or construction having a commercial purpose beyond preventing the tenant from a statutory renewal. This is the no commercial purpose ground of appeal. And when we, in our written case or in my oral submissions, refer to works being artificial, we mean works that don't satisfy this test. Their only purpose is to prevent the tenant obtaining a new lease. We do not say that a landlord has to prove that its works are reasonable or for the public benefit or in the interests of good estate management. We say only that ground F implicitly contains a minimum safety net, namely that the works must have some commercial purpose other than removing the tenant. Secondly, it is our case that a landlord does not intend to demolish, reconstruct or carry out works of construction within the meaning of ground F, where it has decided to carry out the works if and only if those works are necessary to satisfy ground F. This is the conditional intention ground of appeal. We say that if a landlord does not intend to carry out works if it obtains vacant possession voluntarily from its tenant, it does not have the necessary intention for the purposes of ground F. It does not matter for this purpose that there may be little prospect of the tenant in fact leaving voluntarily. If the landlord's intention is qualified in that way, it does not satisfy the requirements of ground F. My ladies and my lords, I propose to address my submissions by giving a very brief overview of the key facts and then under 7 headings. Firstly, an overview of the 1954 Act and the background to it. Secondly, the approach to construction, including the Ramsey line of cases. Thirdly, the no commercial purpose ground of appeal. Fourthly, the conditional intention ground of appeal. Fifthly, I'll deal with the motive cases relied on by the respondent. Sixthly, and very briefly, I'll address reasonableness, sensibleness, and good estate management. And lastly, if time permits, seventhly, I'll deal with some questions on settled practice and legislation by omission. Otherwise, if time does not permit, I'll deal with those matters in reply. My ladies and lords, by way of housekeeping, I should tell you that the good news is that the electric bundle is paginated in the same way as the hard copy bundle, so we hopefully are on safe territory there. But the bad news is that 2 pages were omitted from the bundles and one turned out inexplicably blank, I'm afraid. And your lordships have on your desk a pack with those additional pages, together with 2 additional authorities that we would wish to refer to.
Thank you.
So turning very briefly to the factual background, your Lordships would have seen that the facts are set out in the Statement of Facts and Issues and in Mr Justice Jay's judgment, but just to briefly recap, the tenant occupies premises on the corner of Jermyn Street and Duke Street, St James. It specialises in antique tapestries and textile art and occupies the premises as a retail art gallery, showroom and archive. The premises are part of a larger building, most of which is the landlord's hotel. The tenant has two holdings under the 1954 Act, comprising a principal lease and a supplemental lease of some storage areas. The contractual term of both expired on the 1st of January 2014, and the tenant continued in occupation under the Act. On the 16th of March 2015, the tenant sought to exercise its right to renew the leases by serving requests under Section 26 of the Act for new tenancies to commence on the 3rd of January 2016. The landlord decided that it did not wish to retain the tenant as its tenant. It was prepared to do whatever was necessary to get the tenant out. So it set about devising a scheme which would bring it within Ground F. And by the time of the County Court trial in January 2017, the relevant works which it said it intended to carry out were known as Scheme 3. The landlord offered an undertaking to carry out that scheme, which was accepted. The works were estimated to cost in the region of £776,000. To understand what Scheme 3 does, you have to take one step back to what was called Scheme 2. Scheme 2 involved combining the premises leased to the tenant with part of the hotel, a former bar at ground floor level, and then dividing up the combined space to create two retail units. But there were two problems with Scheme 2 from the landlord's perspective. Firstly, they'd been advised by their solicitors that Scheme 2 was probably not sufficiently substantial to satisfy Ground F. And secondly, the landlord required planning permission, both for external works to create the facade, to create a new doorway onto Jermyn Street, and importantly, for change of use. The premises have a specific sui generis planning use. The hotel bar obviously had hotel use for planning purposes. Both needed to be changed to retail in circumstances where Westminster City Council's policy is to protect existing art gallery uses. The landlord had applied for planning permission for Scheme 2 in November 2015, but it was recommended for refusal and withdrawn in November 2016. So Scheme 3 was designed to meet both of those issues. It took the internal works from Scheme 2, those that would not require planning permission, and added a number of additional works which were designed to maximise the amount of demolition, reconstruction or construction in the scheme. And some of those elements were particularly contrived, for example, digging out and lowering part of the basement floor by 15 centimetres. The result is a scheme of works which would render the premises completely unusable by anybody. It would combine two spaces with completely different planning uses, which couldn't lawfully be used together by a single user. The spaces would be divided into two at basement and ground level, but there would be no external door for the second unit, and the dividing wall at ground floor level would stop 2 metres short of the facade, because to complete it would require planning permission. The procedural position, my ladies and my lords, is as follows. The landlord's opposition to new tenancies was ordered to be heard as a preliminary issue. By order of the 6th of March 2017, His Honour Judge Sagerson dismissed the tenant's claim for new tenancies. The tenant appealed to the Queen's Bench Division on 9 grounds. In July 2017, Mr Justice Jay allowed the appeal on 2 of those grounds, but not those related to the issues before this court. And he remitted those 2 issues to the County Court for further consideration, and that remission is currently stayed. As you know, he gave permission for a leapfrog appeal on the issues before this court, but there are also matters in the Court of Appeal. The landlord has appealed Mr Justice Jay's order to the Court of Appeal. Permission has been given, but that has been stayed, and the tenant has also sought permission to appeal another issue in Mr Justice Jay's order to the Court of Appeal. That is also stayed. But if this appeal is allowed, it will determine the preliminary issue in favour of the tenant and allow the County Court to grant new tenancies if they are not agreed. So the first part of my submissions deals with the overview of and background to the 1954 Act, and I propose to look at the key provisions of the Act a little bit at its historical context and the external materials which were available to assist with its construction. So if I could ask your Lordships to take up the Authorities Bundle 1, please. I should just note that you may have seen that Appendix 1 to our case, which is at Core Bundle, tab 5, page 119, Electronic Bundle, page 119, summarises the key provisions of the Act, so I hope I can take this fairly swiftly. Behind tab 1, page 443, the Act starts, and at page 434, subsection 1 sets out the tenancies to which the Act applies, the key criterion being occupation for the purpose of a business or for those and other purposes. Business is very broadly defined by subsection 2, including trade, profession or employment, and including any activity carried on by a body of persons, whether corporate or unincorporate, so it would include, for example, a club. Subsection 3 defines the holding, essentially the part of the premises which is occupied by the tenant for business purposes. In this case, all of the entirety of the premises is occupied for those purposes. Section 24 on page 435 is the key section which continues tenancies after the end of their contractual term and gives the tenant or the landlord a right to apply to the court for an order for the grant of a new tenancy. Section 24, subsection 2, provides for limitations on the common law rights of both parties to terminate the tenancy. In particular, a landlord cannot terminate a tenancy under a break clause or by notice to quit, as well as by a fraction of time. Section 29 at page 443 requires the court to grant a new tenancy subject to the provisions of the Act. By section 29, subsection 2, a landlord can apply to the court for an order that the tenancy be terminated without the grant of a new tenancy. So both landlords and tenants can apply to the court to bring matters before the court. In that case, section 30 applies, and that's apparent from subsection 4, which sets out the grounds of opposition. Yeah. Section 30 on page 445 sets out the grounds on which a landlord may oppose the grant of a new tenancy. A, B and C are the fault grounds, essentially, relating to the condition of the premises, the payment of rent or other substantial breaches by the tenant.
I think you can assume, Miss Wicks, that we are reasonably familiar with the Act and also with the background of the Act.
That's extremely helpful.
We are much more interested in the issues.
Thank you, my lady. Then I shall take that as read, and I'm very grateful for that indication. My lady, you've indicated you're familiar with the background to the Act. I'd just like to highlight and develop.
Well, I was a member of the Law Commission, and the Law Commission's
I know your lady indeed
examination of this subject. Well, not your subject, but the Act.
Indeed. But going back in time from your ladyship's time at the Law Commission right back to before 1954, as you'll have seen, a key aspect of the context was dissatisfaction with the operation of the relevant provisions in the Landlord and Tenant Act 1927, which gave business tenants some compensation upon expiry of their leases. And it was perceived that there were 4 key problems with the 1927 Act provisions. Firstly, it was limited in scope, it didn't apply to professionals. A tenant or its predecessors in title had to have had 5 years occupation before it could claim. Secondly, the Act looked at the issue of security for business tenants through the wrong end of the telescope. The primary remedy was compensation for leaving, whereas what the business tenants wanted was the right to stay. It was possible to obtain a new lease, but only by jumping the compensation hurdle. Thirdly, the compensation was the wrong measure of compensation. It didn't reflect what the tenant was losing by having to go, but only what the landlord gained by way of adherent goodwill. And fourthly, it was very complicated and difficult for tenants to prove adherent goodwill, and many of them failed at that hurdle. So I'm grateful to my lady for indicating that you're familiar with the background. You've seen that we have relied on the two reports of the Leasehold Committee, the interim report of June 1949 and the final report under a new chairman in June 1950, and also a white paper in 1953. And you'll also have seen that we refer to some short passages from Hansard. Not going to take you
I don't think they're going to help us answer the question.
They probably won't help. They are simply for context, yeah. My lady. Then turning to the approach to construction that we rely on. Of course, we rely on a conventional purposive approach to construction, but we do look at the Ramsay line of authority as providing a useful way of approaching artificiality. Obviously, those tax cases starting in the 1980s with Ramsay, Burma Oil and Furness and Dawson have been considered a number of times at this level. And as you are aware, the approach involves determining the nature of the transactional event to which a statutory provision is intended to apply through a purposive construction, and deciding whether the actual transactional event viewed realistically falls within the statutory description. It is, of course, not a special rule relating to tax statutes, just an emphasis on the need for the ordinary principles of purposive construction in an area which had historically been dogged by literalism and formalism. It is, my ladies and my lords, worth bearing in mind that although the three 1980s cases affected a substantial change in the approach of the courts, the impact was not fully recognised or understood, and the approach has needed to be comprehensively clarified on a number of occasions by the House of Lords and this court, particularly in Barclays Mercantile and Mawson in 2004, and that may be relevant when you come to consider some of the cases cited by the landlord. My ladies and my lords, I'd like to refer to the UBS case. It's not the most recent Supreme Court case applying the Ramsay approach, but it does helpfully set out the development of the law, and I hope Lord Kitchen will forgive us for specifically concentrating on authority in which he was overruled. So I'd like to take your lordships...
It's not an unusual experience. I'm sure, Lord Kitchen.
I'd like to take your lordships to it, and then I'd like to focus on a particular point which is a source of potential confusion. So if I could ask you to take up Authorities Bundle 1, tab 13, it's page 719. The case concerned taxation of a banker's bonuses. UBS and DB each set up a scheme under which employees were allocated shares in a company set up specially for that purpose. With a view to making the shares restricted securities and so exempt from income tax, the shares were subjected to a contingency which rendered them liable to forfeiture. That contingency was unlikely but possible. In the case of UBS, the contingency was whether the FTSE 100 rose by a specified amount in a 3-week period. This contingency was hedged against, but the hedging was designed not to entirely offset the potential loss. It was a deliberate near miss. In the case of DB, the trigger for forfeiture related to the employee leaving or being dismissed within a short period was a matter which effectively lay within the control of the employee. And this court held that, properly construed, the relevant legislation did not apply to restrictions which had no business or commercial purpose, and therefore, as these restrictions did not, they were to be disregarded for the purposes of the legislation. However, that did not mean that the employees were to be treated as if they had received cash. They were to be taxed on the basis that they had received shares, with the value of those shares reflecting the contingencies to which they were subject, and in the case of UBS, also taking account of the hedging provisions. So, my ladies, my lords, if I could take you please to bundle page 737. This is the judgment of Lord Reid with the agreement of the entire court, and he sets out the Ramsay approach from paragraph 61 through to 68. I wonder if I could ask your lordships to read that, unless you're very, very familiar with it already.
And this case is extensively cited in the printed cases,
Yes, it is.
including this particular passage.
It is, yes. Thank you.
My computer's decided to die temporarily anyway, so
Oh dear.
it'll come back to me.
I particularly want to come back to, in a minute, the point which was made in paragraph 67 about references to reality not being misunderstood. But before I do that, I just want to take up two very short other passages. Page 742 of the bundle, paragraph 77 of the report, makes the point
Paragraph.
that... Sorry.
So paragraph.
Paragraph 77 of the report, my lord, page 742 of the bundle. And it's just the first few lines of that paragraph making the point that the relevant statutory provisions, or the chapter in which they were contained, given that they were introduced partly for the purpose of forestalling tax avoidance schemes, Lord Reid says it self-evidently makes it difficult to attribute to Parliament an intention that it should apply to schemes which were carefully crafted to fall within its scope, purely for the purpose of tax avoidance. The fact that the scheme was aimed at tax avoidance, the Act was in part aimed at tax avoidance, was a clue to Parliament's intention. But then at page 744, paragraphs 81 and 82, see reference to the fact that the taxpayers emphasised that there were detailed tax avoidance provisions elsewhere in the Act. And Lord Reid says in paragraph 82, in some circumstances, the existence of such provisions might support an inference that Parliament's intentions in relation to anti-avoidance have been exhaustively expressed. That is not, however, the position in relation to chapters 2 and 3A. And the conclusion you see on the purpose of construction at paragraph 85 on page 745. Final conclusion, applying that to the facts at paragraph 98 on page 748. I said I wanted to bring out the point made in paragraph 67 about genuine documents and genuine arrangements. The point is that events which are disregarded on this approach are not disregarded because they did not happen. They are disregarded because the statute, purposively construed, treats them as irrelevant. So in the UBS case, there were real shares with real restrictive conditions in them. The restrictive conditions genuinely affected the value of the shares. The restrictions were ignored for the purposes of deciding whether the shares were restricted securities, but they still had an economic effect which was taken into account when valuing the shares. And perhaps to illustrate the point by reference to a rather simpler set of facts, the facts of Furness and Dawson. In Furness and Dawson, the Dawsons negotiated a sale of family companies to a purchaser, Wood Bastow, which would generate a liability for capital gains tax. So in an attempt to avoid that, the Dawsons incorporated an Isle of Man company, Green Jacket, and they exchanged the shares in the family companies with the shares in Green Jacket. Then Green Jacket sold the shares in the family companies to the purchaser, Wood Bastow. Viewed as two separate transactions, no capital gains tax would arise because the share exchange with Green Jacket was exempt and Green Jacket made no capital gain when selling to Wood Bastow. And if I can now just take up the explanation that is given in the Arrowtown case by Lord Millett about Furness and Dawson. That's in Authorities Bundle 2, tab 20, page 1403.
1403.
It starts at page 1403, and I'd like to take up 1441, please. Lord Millett had been the leading counsel for the Crown in both Ramsey and in Furness and Dawson. And you have seen in the UBS case references to the Arrowtown decision. Paragraph 122 of the Arrowtown decision, Lord Millett is discussing Furness and Dawson. And if I can take up just below little b, the Crown did not invite the House to ignore or disregard the disposal to Green Jacket as if it never happened or to treat it as a sham. It did happen, it was genuine, and the Crown accepted that it transferred the full legal and beneficial ownership of the shares to Green Jacket by way of share exchange. The Crown's case was that the fiscal consequences of the share exchange were to be disregarded because it was not the relevant disposal, but only part of it. The relevant disposal was the composite transaction, which consisted of two steps and constituted a disposal of shares by way of sale, with the result that it fell outside the exemption for disposals by way of share exchange. The House of Lords agrees. And turning over the page to page 1442 of the bundle, Lord Millett sets out a passage from the speech of Lord Brightman in Furness and Dawson at the top of the page. And if I can just take out the paragraph just above letter C. Secondly, there must be steps inserted which have no commercial business purpose apart from the avoidance of a liability to tax, not no business effect. And then Lord Millett goes on in paragraph 125. The Court of Appeal had rejected the Crown's claim, ruling that the disposal to Green Jacket could not be disregarded because it had enduring legal consequences. Green Jacket remained in existence after completion of the sale and received the purchase money which the taxpayers could not extract from it without adverse tax consequences to themselves. The insertion of Green Jacket therefore had a commercial effect, but the House of Lords held that this did not matter. It was no part of the taxpayers' purpose, but rather the price they had to pay for the hoped-for exemption from tax. Lord Brightman did not disregard it in the sense of treating it as if it had never taken place. He disregarded it for fiscal purposes, that is to say, for the purpose of applying the statutory charge to tax on a disposal, which had certainly taken place, and the statutory exemption in respect of a disposal by way of share exchange, which had not. He did not disregard it because Green Jacket's acquisition of the shares was and was always intended to be ephemeral, nor because the routing of the shares through it was motivated by a desire to obtain the benefit of a tax exemption, but because it had no other purpose. To use the landlord's phrase, the Dawsons in Furness and Dawson put their money where their mouth is. They paid real money to incorporate Green Jacket, which had real legal personality. They transferred real property to Green Jacket in the form of the legal and beneficial interest in the shares. And Green Jacket undertook real contractual obligations to the purchaser and became the real owner of the purchase price. But because the share exchange had no commercial purpose other than avoiding tax, it was disregarded, and the transaction was treated for tax purposes as if it were a sale by the Dawsons for money which was paid at the Dawsons' direction to Green Jacket. We've also seen in Lord Millett's judgment the difference between the no commercial purpose test and a general motive test, if you like. If there had been a commercial reason for the share exchange in Furness and Dawson, it would not have been disregarded, even if the taxpayer's motive was avoidance of tax. It was disregarded because it was entirely artificial. It was affected for no reason other than avoiding tax. So it's the fact that a tax may be generally motivated to avoid tax is not the relevant test. Does it have any purpose other than avoiding tax? My learned friends cite a number of cases in the landlord and tenant or property field where a Ramsey approach has been argued for but not succeeded. I'll come back to those in reply as necessary. I'll just comment at this point that most of those cases are explicable simply on a straightforward basis that purposively construed the relevant statutory provision did not require an event without commercial purpose to be ignored. But some are based on a failure to appreciate that a statutory provision may require an event or transaction to be disregarded, even though the arrangements are genuine and real money is paid or real property is transferred. Just before moving away from the approach to construction, I would note that the landlord also adopts some of the statements made in the pre-Ramsey tax cases, but in doing so fails to reflect the qualifications which the Ramsey approach requires to those dicta. So, for example, it seeks to apply to ground F the dictum of Lord Tomlin in the Duke of Westminster case that every man is entitled, if he can, to order his affairs so that the tax attaching under the appropriate acts is less than it would otherwise be. But without reflecting what Lord Diplock said in Burma Oil, namely that the dictum tells us little or nothing about what methods of ordering one's affairs will be recognised by the courts as effective. And in any event, we say whatever the continuing influence of that dictum in the tax field, it has no application to the Landlord and Tenant Act 1954. Turning now to the third section of my submissions, the no commercial purpose ground. Under this heading, I'd like to explain exactly how our case is put and develop some of the 9 points that we make in our written case as to why this is the way in which ground F should be construed. If I could ask your Lordships please to take up our written case in the core bundle, tab 5, page 103. And our case on this ground of appeal is reflected in paragraph 44. We seek a purposive construction of ground F, and we seek to apply that to the admitted facts. So we say properly construed ground F applies only where the demolition, reconstruction or work of construction which the landlord intends to carry out has a commercial purpose beyond preventing a business tenant from obtaining a statutory renewal.
Can I just ask you to focus on
course.
commercial within that test? A landlord may have a country estate with an unsightly barn at the end of the driveway in the way of some otherwise pleasant view and wish to have the barn removed for a purely aesthetic, i.e. non-commercial purpose. Yes. You're not suggesting, I think, are you, that that would disqualify him from running the demolition ground, even though, of course, removing the tenant within the barn assisted in improving the view, rather like removing the barn?
We say it needs to be borne in mind that all landlords of business premises are inherently investors in commercial property. So they may be individuals, but the nature of their interest is an investment in commercial property.
But your argument would be exactly the same.
Yes, it is.
Or if the word commercial were removed. Your point is that there's no purpose beyond preventing business tenants.
Yes.
That's what I was seeking to teasel out.
Yes, I'm sorry. I didn't answer your question quickly enough. Yes, we say that the word commercial has a very broad meaning and a commercial purpose would include an aesthetic reason. So it would include my Lord Orbrig's example of...
Well, you don't have to say that, do you? The only purpose of putting the word commercial here is that we happen to be dealing with a context where the sole value of this property to the relevant parties is a commercial one.
Yeah. Yes.
But it's the absence of purpose rather than its commercial character that is the critical point in your argument.
Yes, that's right, my assumption, that's right. It's the absence of purpose other than removing the tenant or preventing a statutory renewal. That's absolutely right. My lords and ladies, there are 5 points that I'd ask your lordships to note about our case in this respect. Firstly, and it obviously flows from the way that we put the test, but it may not be immediately obvious, that a scheme of work does not fulfil ground F simply because there's a commercial purpose in preventing the tenant obtaining a new lease. So there will often be very good reasons, good commercial reasons, why a landlord wants to have vacant possession. Often it will give it a free hand to do what it likes with the premises or to replace the existing tenant with a new one. But we submit it's important to differentiate between having a good reason for wanting to get rid of the tenant from having a purpose, commercial purpose, in carrying out the works themselves. Secondly, the qualification to ground F for which we argue is a qualification about commercial purpose, not commercial effect. So just as in the Ramsey cases, it's irrelevant that the works will cost money, that they will be real, and that they will, if they are carried out, have a physical presence. They are disregarded, we say, because however real they have no commercial purpose except preventing the tenant from exercising its statutory rights. And purposefully construed, ground F requires such works to be disregarded. The landlord says, well, we're prepared to put our money where our mouth is by paying to fulfil the undertaking to carry out Scheme 3. But in Lord Millett's words, that is just the price which the landlord agrees to obtain its hoped-for ability to remove the tenant. Thirdly, on our test, a landlord does not fail ground F simply because it is motivated by a desire to get rid of the tenant. It is free to put forward a scheme of works which is motivated by that desire, as long as the works also have some purpose other than removing the tenant by satisfying ground.
So you're using the word purpose objectively.
Well, my lord, there are nuances.
Otherwise, how do you distinguish between purpose and motive?
My lord, I think when it comes down to it, both are concerned with the reasons why the landlord does something. So it's difficult to see that there is a strong difference between motive and purpose in this context. Both mean...
If you're relying on the Ramsey, Furness and Dawson line of cases, they depend on an objective assessment of the purpose, having regard to the relationship between the different parts of the transaction. They're not concerned with subjective motive at all. And I don't see that you need to be either.
My lord, you're absolutely right, my lord. There are nuances in the English language between the concept of motive, which sounds like something that just happens in somebody's head, and the concept of a purpose, which sounds like something that you can objectively determine.
Precisely.
Well, my purpose on getting on a train to Manchester is to go to Manchester.
Yes.
My motive in going to Manchester maybe is completely something other. It's because I want to go there, I like the weather or whatever.
Yes, but if you're asking about...
scenarios.
My lady, if you're asking about what is the purpose of the works or what is the motive for the works, you're asking a very similar question because you're focusing on one matter that you're concerned with.
Why do you formulate it this way rather than saying it fails where the only purpose is to get rid of the tenant?
That's just linguistically the same way. It's the same thing. It's just we've put it in rather a longer sentence, I suppose. But it has the same. It's the same concept. We say ground F does not apply where all the landlord is trying to do, the only reason it's trying to do its works is to get the tenant out.
Suppose that there are two purposes, one of which is to get the tenant out, which is probably the normal state of affairs, and the other is that the reconstruction is
Yes.
has objectively ascertainable advantages. Your submission, I mean, you don't need to assume the burden of saying that is outside the scheme. No. And as I understand it, you're not submitting that that's outside the scheme.
No, we're not.
So the mere presence of a desire to get rid of the tenant doesn't, so to speak, infect the whole scheme. Your submission is directed to the rather stark facts of this case when there's frankly nothing else.
That's absolutely right, my lord. That's absolutely right. We recognise that landlords live in the real world. They live. They have to make their decisions in the real world about what they may need to do, and they may decide on a scheme of works which is useful to them, but will also help them satisfy Ground F. But that's different from this case, and we don't seek to exclude a case where a landlord has in its thought process a desire to get rid of the tenant, as long as the works have some purpose beyond getting rid of the tenant.
And likewise, you're not addressing the question which is the primary or dominant purpose for the same reason.
No, that's absolutely right. And I should just say that in that respect, the way in which the leapfrog appeal grounds were formulated, and so on which permission to appeal has been granted, uses the language of sole or predominant objective, which reflects the language used by Mr. Justice Jay. But we don't rely on the predominant aspect. We only rely upon the sole aspect. And it's also worth noting that our test would apply not only to entire schemes of work like Scheme 3, which are designed solely for the purpose of removing the tenant, but also to particular items of work which are added to beef up a scheme which does otherwise have this purpose. So, for example, the Leasehold Committee gives the example of removal of a shop front being insufficiently substantial to justify removal of the tenant. Now, a landlord may have a good commercial reason for wanting to remove a shop front. It can't turn failure, because the shop front is not sufficiently substantial, into success on Ground F by not only removing the shop front, but also digging out the floor by a few inches or removing and then replacing a wall.
So your submission extends to that part of the works which has no purpose, even if some other part would satisfy your test, but possibly fail the substantial test.
Yes, exactly, my lord. So in that case, the court would disregard the work which is without commercial purpose and judge the remainder. And in fact, that's an exercise that the courts are used to doing already, because a single scheme of works will often include works outside the holding which have to be disregarded, or they may include works which can be effected under a right of entry. And so it's already necessary for the court, considering a package of works, to discount certain works because they fall outside the test of Ground F, and then consider only the remainder. And in fact, Mr. Justice Jay referred to that process. It's paragraph 117 of his judgment. And fifthly, as I've explained in answer to my Lord Briggs, we don't use the word commercial to distinguish it from residential purposes or other purposes. In the unlikely event that a landlord of business premises really did want to knock down the holding and build a folly, it can do so. That's folly is a piece of architectural art which the landlord clearly perceives enhances the amenity or aesthetics of its land, and that would satisfy Ground F on our test, even if the folly isn't built with a view to generating a profit.
I'm slightly troubled how your point 4 works in relation to add-ons. I mean, a sophisticated surveyor could look at a scheme of works and nitpick his way through, saying, well, that bit, and that bit, looked at separately, don't really have any commercial, i.e. other than removal of the tenant purpose, even though as a whole it plainly does. How's that going to be tested? I can see a smoking gun case in which Scheme B just fails to satisfy F, so they add on something completely purposeless to turn it into Scheme C, and lo and behold it qualifies. But how do you distinguish between those two different situations if you're looking at it objectively?
Well, my lord, take the facts of this case. So the landlord had Scheme 2, which
yes.
would have had two
well, this is,
units.
You've got that sort of historical point in this case, but there may be many in which it doesn't appear to work historically in quite that way.
Well, there may be. There are always difficult questions of fact to be addressed by the courts under Ground F. But as I've explained, the courts are used to looking at a scheme of works and saying either I disregard this because it's not work of demolition, reconstruction or construction, for example, or I disregard these items because they are outside the holding, or I disregard these items because the landlord can effect them under a right of entry. And I look at what's left, and it's a complicated question, and the courts recognise that it's a complicated question of fact, but it is still one that's capable of being done. And it isn't a very difficult, it isn't a very high hurdle for the landlord to jump to show that it has some commercial purpose. If the landlord in this case had been able to say, well, the reason I want to dig out the floor and lower it by 15 centimetres is because we need more headroom in the basement, then that item of work would have a commercial purpose. But in fact, in this case, it was simply in order to create a lot of demolition work. But my lord, we would suggest that county court judges are willing and able to grapple with these questions. They have to already.
With a case where the tenant, at least on your submission, has deliberately left unclear what it intends to do once it has removed
The landlord, my lord, yes.
what the landlord proposes to do has been deliberately left unclear. Is a way of getting around your formulation for the landlord simply to say, well, I want you out, and I am in the process of formulating new purposes and plans for this particular building.
No, my lord, that would not.
How do you put a temporal limit on it?
Because Ground F already has a temporal limit on it. It requires the works of demolition, construction or reconstruction to be carried out at the termination of the current tenancy. So the court has to look at what does the landlord intend, what is the intended scheme of works that the landlord wants to do, and ask itself, looking at that scheme of works, does the landlord intend to carry out that scheme of works on the termination of the current tenancy? It also has to say, does the landlord reasonably require possession for the purpose of carrying out that scheme?
So it's built into the analysis.
It's built into the analysis that a landlord can't come forward and say, I want to get the tenant out and I haven't really worked out where I go next. Because in that case, the works are only for the purpose of getting the tenant out.
Well, you have to come to court with a complete scheme and give evidence that that's what you propose to do. You can't give evidence that you propose to do something or other which would be sufficiently inconvenient to require you to have vacant possession.
No, indeed. You might come forward with two schemes. A landlord sometimes says, I definitely want to do either A or B, and for some reason perhaps...
And both of them would pass.
But both of them necessarily require me to get the tenant out in order to have possession, in order to be able to carry out these works.
Does the same apply to demolition?
Yes, my lord, demolition...
The landlord's got to come forward with a plan saying, I'm going to demolish this building, and in its place, I'm going to do such and such.
So the landlord is judged under Ground F by what it intends. So it has to bring forward the entirety of its intention, which means what has it decided to do? And the court then judges what it has decided to do. And there are lots of good reasons why a landlord may, for very valid commercial reasons, want to demolish either wholly or partially a holding. If the holding is an entire building, then it might want to demolish in order to have a public open space, or to remove an eyesore, or to have a car park, or to have an agricultural holding, which is one of the examples in the cases. And also, we need to bear in mind that a holding may not be an entire building, it may be part of a building. So the landlord may want to demolish a holding which is part of a floor in order to create a larger space with the rest of the floor of that building. Or it may want to demolish or partially demolish a holding which is just on one floor in order to combine it with another part of the building.
And most of those are likely to be reconstructions, aren't they?
Many of them will be reconstructions, but some of them are complete demolition on their own. So, for example, Houseleys and Bloomer Holt involves demolishing a garage in order to have a turning circle for lorries. That's just an act of demolition, but it has a commercial purpose, it has a real purpose. Does that answer your Lordship's question? Just to be clear, the facts on which we rely for saying that the landlord had no commercial purpose, no purpose other than removing the tenant, are recorded in the Statement of Facts and Issues, which is in the core bundle at tab 4. It starts at page 73. And if I can take your Lordships, please, to paragraph 29 on page 81. And you see recorded there the finding of Judge Sagerson and what the evidence revealed, that the landlord had resolved to carry out the scheme 3 works only because it understood that they were necessary to establish ground F, thereby obtain vacant possession, and not for independent commercial reasons. And the landlord's witness agreed scheme 3 was designed purely for the purpose of satisfying ground F. And if I can also take you, please, to paragraph 25.2 on bundle page 80. Makes the point that the landlord used the fact that the defendant was trying to get the tenant out as a reason for demonstrating why it was so firmly settled on carrying out Scheme 3. Then I need to contrast that on page 82 of the bundle, paragraph 30 of the Statement of Facts and Issues, with what the landlord said were its reasons for wanting to get rid of the tenant. So not its reasons for carrying out the works, but its reasons for wanting to get rid of the tenant. The witness said that the landlord perceived the commercial logic behind the removal of the tenant to be the facilitation of a longer-term plan to undertake major works for the addition of 28 hotel bedrooms to the hotel. That's on the upper floors, which it said it perceived the tenant would seek to frustrate. So it was a question of, as the landlord put it, of course my client doesn't accept that, it was a personality issue. My lords, on this point I should just take you to right at the end of the landlord's case. It's core bundle tab 5, page 267.
Which paragraph in that case?
It's paragraph 39 of Appendix 4. It's right at the end. And what is suggested here is that the work, Scheme 3, is not artificial because the landlord believes that the works are of commercial value and utility to it, because undertaking them will remove the appellant from occupation, and this will in consequence facilitate the future redevelopment of the hotel building beyond the holding occupied by the appellant. I want to be clear, this confuses the commercial purpose of doing the works with the commercial reason for getting rid of the tenant. Over the page, at page 268 of the bundle, the landlord cherry picks a small part of the evidence to support its proposition. In our submission, it's completely wrong to have done so. It's a very small part of a witness statement which doesn't reflect the evidence that was given under cross-examination, and that evidence, the complete evidence, is reflected in the Statement of Facts and Issues and is agreed. So in our submission, there is both a finding in His Honour Judge Hutchison's judgment and importantly, an admission, both reflected in the statement of facts and issues, to demonstrate that there was no purpose beyond removal of the tenant in Scheme 3.
Going back to paragraph 30 of the statement of facts and issues,
Yes.
had the landlord resolved to do any of these things at the time of these proceedings, that would, on your submission, as I understand it, have been entirely permissible.
My Lord, the hotel works wouldn't have required possession of the premises. So the hotel works wouldn't satisfy Ground F because they were to the upper floors of the hotel. Then, just
You
back.
presumably say a deeper flaw in the analysis in the respondent's case, which you've just pointed out, is that it wrongly assumes that artificiality is any part of your test.
Well, as I've said, we use artificial just as a shorthand because it's rather a mouthful to say without a purpose other than removing the tenant. But that's what if we use the word artificial, that's what we mean. If I could then go back to page 103 of the bundle, core bundle tab 5, page 103.
103.
I'm so sorry.
Did you say 103?
103, please, my lord. We're back where we were, and I just want to briefly develop some of the points that we make. As I said, we set out 9 reasons why we say Ground F should be construed in this way, and I'm not going to repeat those, but just pick up on a couple of points. Firstly, in paragraph 45, we say that the qualification for which we argue is necessary to reflect the policy of Ground F. The landlord repeatedly puts up a straw man by suggesting that we're contending for a statutory test which requires works to be beneficial or in the public interest, and we do not. We simply say that because Parliament legislates in order to protect the interests of the landlord which wishes to carry out redevelopment for commercial reasons, and because redevelopment is in the public interest, it is apparent that it did not intend Ground F to be satisfied by works which have no purpose except removing the tenant. In that context, it's also suggested that demolition can't have a commercial purpose, effectively, and I hope, in answer to my Lord Kitchen, I've dealt with that. Paragraph 46 of our case, at page 104, deals with the problem for the efficacy of the Act if Ground F is to be read as the landlord contends. Put shortly, my ladies and my lords, we say that if the landlord is right, the 1954 Act is badly holed under the waterline and sinking fast. An Act that was intended by Parliament to impose on all landlords the standard of good landlords essentially becomes voluntary on the part of the landlord. Many landlords probably wouldn't actually ever need to carry out their artificial schemes of works. They'd simply present their tenants with a list. These are the works that we're going to do. This is the undertaking that we're going to give the court. And in those circumstances, what tenant is going to pay thousands of pounds to go to court to secure an undertaking which brings it no benefit at all? And that problem arises not only at the end of the tenancy, but also where there's a landlord's break clause or a redevelopment break clause. Many commercial leases, many business leases have a landlord's break clause. The operation doesn't bring the tenancy to an end, but does require Ground F to be satisfied. And if the landlord is right, it can satisfy it with very, very little difficulty. Next, at paragraph 47 of our case, page 105, we make the point that taking your lordships to in the UBS case, that we can see that the Act contains a number of provisions which were designed to prevent or designed to guard against the risk that landlords would adopt devices to prevent business tenants renewing their leases. We see that both in the original form of the Act, for example, the 5-year rule in Section 30, subsection 2. We see it in the misrepresentation provisions, now in Section 37A, previously in Section 55 of the Act, where the landlord potentially becomes liable for all of the losses which the tenant suffers by being refused a renewal if it has misrepresented the position or concealed material facts. It's not simply a positive misrepresentation which gives rise to liability, but concealment of material facts. And we say that provision in particular indicates that Parliament expects landlords to be honest and also to give the court full information about what they intend to do. If the landlord is right, then all landlords have to do when they come to court is say, I really, really, really want to get this tenant out and I'm prepared to pay whatever it takes to get the tenant out. And we say it's highly unlikely that Parliament intended Section 37A to be satisfied, sufficient material facts to have been brought forward and not concealed by the landlord honestly giving the court the reasons why it wants to get rid of the tenant. I won't take any further than we've put in the written case our points in paragraphs 48 and 49. 48 is, this equates to a buyout of the tenant's rights. 49 is effectively the tenant gets inadequate and arbitrary compensation instead of a right to renew. But if I could just take up paragraph 50 on page 106, please, which is the function of section 38 within the Act. Landlords and tenants have a choice about whether or not to enter into the scheme of the Act. They can contract out of it, but only on the basis that the tenant has a full understanding of the consequences of doing so. And clearly, the tenant who has a full awareness of the consequences of contracting out the Act has the opportunity to bargain for a different rent or other terms of a tenancy when being asked to contract the lease out of the Act. Once, however, the parties are within the scheme of the Act, the ability of the landlord to unilaterally exit from that scheme is very carefully defined. It has a right of forfeiture which is preserved. Otherwise, it can only exit the scheme of the Act effectively unilaterally on the grounds set out in section 30, subsection 1. And its ability to consensually exit is also carefully circumscribed. The landlord can make an agreement with a tenant for a surrender of the tenancy, but only where there's been an adequate health warning given to the tenant. It can accept an actual surrender. That's, of course, something that the tenant wants to achieve. But otherwise, whilst the parties are within the scheme of the Act, Section 38 applies, and we've set it out in paragraph 50 of our case. So we say that it is important it's necessary to imply the qualification which we suggest into ground F in order to maintain the integrity of the statutory scheme. Lords, paragraph 51 deals with the role of the planning authorities. I won't take that any further. Paragraph 52 deals with the cases on ground G. And again, we've put that out comprehensively in our case. But if I can just take up the Major Stake and Curtis case, which is dealt with in paragraph 53. That's in Authorities Bundle 1 at tab 9, page 653. No, my lady, here will be.
Is this the landlord's red line?
The landlord's red line, indeed, my lady, that's right. So it concerned the redevelopment ground in the Leasehold Reform, Housing and Urban Development Act 1993, insofar as it related to an individual lease extension right. And what the landlord said it wanted to do was it wanted to combine the tenant's flat with the flat immediately below it. And the question was whether this constituted the redevelopment of any premises in which the flat is contained. So the focus of the decision was on the question of what constitutes any premises. We recognise, of course, that the context and policy objectives of residential landlord and tenant acts differ from the business tenancies legislation. But in our submission, the policy which underpins the redevelopment ground in these different pieces of legislation are likely to be broadly similar. And indeed, if we turn to the judgment of Lord Carswell, at page 670 of the bundle, it's the last page of the report, page 804. He deals with this at letter E. I think there's a word missing from the report. I think it should read, the landlord must be entitled to possession for the purpose of redevelopment in the interests both of a fair balance between landlords and tenants and in those of a healthy property market and the maintenance of good quality housing stock. So we see very similar policy reasons to those which we say underpin ground F, both the interests of individual landlords, because that's important for a healthy property, both the interests of individual interests of landlords and also in the public interest in having a properly functioning property market, which means it's important to have a good quality supply of modernised business premises. My ladies and my lords, there are, as we've said in our written case, two quite distinct strands of reasoning in the speeches in Major Stake. It's suggested by my learned friends in their case that the only basis on which the landlord failed in this case was because essentially the works weren't sufficiently substantial. But in our submission, it is quite clear as well that artificiality was also a concern for their lordships. And if I can just flag the relevant passages so that you have them. Page 657 of the bundle, 791 of the report. Lord Hope deals first with substantiality at letter C.
What's the paragraph number?
Paragraph 4, my lady.
Thank you.
Paragraph 4, and it's where the right to acquire a new lease of a flat. He goes on to say that's why an intention to redevelop something more than the flat itself is required. So that's about the redevelopment ground in the 1993 Act needing to be focused on works of a sufficient scale. But then he goes on in that same paragraph, but a little bit later, and in hard copy it's just above letter D, he says, the argument that it is open to the landlord, he talks about units of that kind would be artificial. They would have been put together simply to achieve the statutory requirement, and they could not, in the proper sense of the phrase, be said to be premises in which the flat is contained. So clearly we have both substantiality and artificiality being a reason for the decision in Lord Hope's judgment. If I can then turn to my Lady Hale's judgment, with which Lord Walker agreed. It's bundle page 666, paragraph 37.
Lord Hope also agreed.
Sorry.
Lord Hope also agreed.
Yes, my lady. That's right. We see again, paragraph 37, your ladyship dealt with the substantiality point. But at paragraph 38, on bundle page 667, we see you dealing separately with the artificiality point. It can't have been Parliament's intention to allow the landlord to define the premises for itself. That would in many cases allow it to defeat the right to a new lease.
Sorry, paragraph?
Paragraph 38, my lord.
Thank you.
And similarly in Lord Carswell's judgment, the last page of the report, page 670 of the bundle, It's a very long paragraph. It is part of paragraph 47, but it's about a third of the way down the page. He starts, secondly, I'm influenced by consideration.
Sorry, which page are you on now?
Bundle page 670, my lord.
Thank you.
It's the passage starting, secondly, I am influenced by consideration as a statutory objective. He talks there about the scale of redevelopment required, referring back to Lady Hale's judgment, paragraph 37. So he's dealing there with substantiality. And then in the same paragraph, but a little later on, towards the end, it's letter E, if you have the hard copy. I'm impelled to agree, however, that to allow the landlord to cherry-pick among separate flats, assembling what may be regarded as artificial units and obtain possession in order to carry out small-scale conversions such as the present would be contrary to the apparent intention behind the legislation. So, my ladies, my lords, we say the House of Lords in major stakes sought to protect residential tenants against landlords with artificial schemes because that would undermine the rights given by that legislation, and the same applies.
It's not so much an artificial scheme as an artificially identified unit, isn't it?
Yes.
I'm just not sure how much of a crossover there is into this.
You know, the whole point was that the landlord claimed the right to be able to draw a red line round the plan of the building in order to prove that it was both substantial and to defeat the infringement or defeat the extension. These were just reasons to say you can't do that there here.
Yes.
Premises have got to mean something objectively recognisable as premises. Yes, I'm not quite sure how it translates.
No, we don't want to push it too far. It's merely an example of it's the only example we have of a redevelopment ground being considered at this level of court. And we see it being purposively construed in order to ensure that the rights given to the tenants are effective, and with a concern that otherwise the landlord can draw its own red lines. But, my lords, my ladies, that is essentially what we have here. We have the landlord saying, I can bring forward whatever works I want to without any reason other than getting the tenant out. They are entirely artificial. So it's a different kind of artificiality. My Lord Briggs is right. It's not the artificial drawing of a line, but it is the artificial bringing forward of works for the purpose simply of removing the tenant. My ladies and my lords, it's suggested that our construction of Ground F would raise practical difficulties, but we don't accept that. We say that the tax cases show it is possible to apply a no commercial purpose or no purpose test. That doesn't mean that the application to the facts will always be easy, and often there will need to be inferences drawn. But the first tier tribunal in tax cases manages it, and we suggest that the county court judges can also manage it. And in the case of Ground F, the court is assisted by the fact that the court is already concerned with the state of mind of the landlord. The courts are already exploring the reasons why a landlord is proposing to carry out works in order to be able to understand whether the landlord is genuine about its intention. So even the landlord here accepts that the wisdom or practicality or prudence of a landlord's proposals may be evidence of its sincerity in asserting that it's going to do the works. So in practice, there won't actually be much, if any, additional evidence directed towards this particular issue. In fact, one would hope that if the Supreme Court tells landlords that they can't include works that don't have a commercial purpose, that they wouldn't then include them in their schemes. But if they do, my ladies and my lords, the courts are already addressing that kind of evidence, but for a slightly different reason. Now turn to our conditionality of intention ground of appeal. And that position is set out in our case at paragraph 54, which is at bundle page 109. We say the landlord does not intend to demolish, reconstruct or carry out works of construction within the meaning of ground F, properly construed, where it has decided, as at the date of the hearing of its opposition to the grant of a new tenancy, to carry out works if and only if those works are necessary to satisfy ground F. And that being the subjective state of mind of the landlord at the relevant time in this case, its opposition to the grant of a new tenancy fails. My ladies and lords, as you'll have seen from the cases, it's settled law in this area that the landlord's intention has both a subjective and an objective aspect, and those derive from the judgment of Lord Justice Asquith in Cunliffe and Goodman, which was adopted for the purpose of ground F in the Betty's Cafes case and has been routinely cited ever since. And we're concerned here with the subjective aspect. My Lord Briggs looked quizzically at me. Did you have a... Is there something I can assist you with?
No. I'm just trying to get my head around the essence of your conditionality argument.
Well, let me hope I can. Let me see if I can explain it to you.
Just to let you know where I'm troubled.
Yes.
Any landlord who wants to do works and generally intends to do so for what you call commercial or other purpose other than getting out of the tenant, will have in his mind that if a court tells him that actually that doesn't satisfy ground F, he can't do the works.
Yes.
So I'm in trouble in thinking why that conditionality isn't always there.
Because we're talking about a different kind of conditionality, my lord, or a different condition. The point is that there are things that will get in the landlord's way because it needs a third party to do something. It needs the court to make an order, is an obvious one, but also a landlord may not be able to carry out works because it needs planning permission. Those are the actions of a third party which the landlord can't control. But, and of course, in that respect, Parliament wouldn't have expected a landlord to fail ground F or indeed ground G because the landlord recognised that its decision to proceed with the works is conditional upon either getting planning permission or getting an order from the court. But the key thing here is that the landlord should have decided that it will carry out the works insofar as it is able to do so. And that's picking up on the judgment in Cunliffe and Goodman. If I can take your lordships to that, please. It's Authorities Bundle 1, tab 4, page 573. And it's in the middle of that page, the relevant passage, right in the middle of the page. An intention, to my mind, connotes a state of affairs which the party intending, I shall call him X, does more than merely contemplate. It connotes a state of affairs which, on the contrary, he decides, so far as in him lies, to bring about. And it's the so far as in him lies that we particularly rely upon. That is to say, so far as he is able to do so. Not about being in the control of other people. It's about what is in the control of this landlord.
I mean, I wonder whether we are, your label conditionality may be slightly missing the real point about this. The requirement of the section is that that he couldn't reasonably reconstruct the premises without obtaining possession. Now, that may be thought to suggest that the intention to reconstruct must exist independently of the presence of the tenant, but the presence of the tenant has got in the way of it. And I think this is the same point that you're making, but it's a different way of putting it, that the landlord's case puts the causation aspect of this completely the wrong way round. Instead of saying, I intend to reconstruct, and the tenant's possession is obstructing it, what he is saying is the presence of the tenant has caused me to intend to carry out the works. And that's not what this section is about. Now, conditionality of the intention may well be part of the evidence that enables one to establish that proposition. But it's not really, the critical point is the causal relationship being the wrong way round, and not the way in which you prove that.
Yes, my lord, and your lordship may be right that the conditionality label may be obscuring the way in exactly the way in which we want to put this particular point. My lords, can I take you, please, to the statement of facts and issues, and we'll see what the agreed state of mind was. And it's bundle page 80. It's, sorry, core bundle, tab 4, page 80. The landlord did not intend to carry out Scheme 3 if it were not necessary to do so to obtain vacant possession. For example, if the tenant voluntarily vacated, or if it were possible to carry out the works without obtaining vacant possession. So the question in our submission is, does an intention of that nature satisfy the test in ground F? We say that Parliament expects the decision that the landlord has taken to be sufficiently firm that the landlord has decided it will do the works if it is within its power to do so. And that's what the Cunliffe and Goodman test tells us. It can't be, I might or might not carry out the works. I want to get vacant possession. I might or might not carry out the works. I haven't decided yet. That wouldn't pass the test, the Cunliffe and Goodman test, because it wouldn't be a firm decision to carry out the works. And in particular, we say the landlord's intention is one step back from that. The landlord can't say, I have decided that I will not carry out the works if I obtain vacant possession otherwise than on ground F. There's actually a firm decision that there are circumstances in which the landlord will not carry out the works. And we say that doesn't satisfy ground F.
So it requires a sort of hypothetical analysis of the landlord's thinking. If the tenant wasn't there, would I be doing the works?
No, my lord, what we're dealing with here
Or if I could get him out by agreement, would I be doing the works?
Yes.
In other words, if he wasn't there, if he disappeared off the scene for reasons unconnected with me getting an order under F, would I do the works?
Yes. Yes.
Is this the same as your Act Free World point?
My lady, it's right to say that Mr. Justice Jay records me mentioning an Act-Free world, and I think that may have been not the best way to put it. What I was attempting to do was capture the point that we make in our written case, namely that Parliament is legislating in the expectation that a landlord which intends to redevelop so as to enhance the value of its investment will redevelop whatever the circumstances are in which it obtains vacant possession. So the key thing is Parliament, under ground F, gives the landlord possession in order to be able to carry out works. And it turns that on its head, and I think this may be my Lord Sumption's point, it turns that on its head to say the landlord won't do the works if it can obtain possession in some other way, if the tenant goes voluntarily or something happens. And it links with the question of the artificiality of the work. So there's a link with the first round that we've covered.
In a sense, it's the inverse of it, isn't it?
They're two sides of the same coin. Yes. Because the reason why the landlord doesn't intend to carry out Scheme 3 if the tenant leaves voluntarily is because the sole purpose of Scheme 3 is to get the tenant to leave. They are the two sides of the same coin, and we say that the policy and textual reasons which apply to the no commercial purpose ground are equally applicable to this ground. It is perhaps just a different way of putting the same point. But to answer my Lady Black's point, our submission is not that ground F mandates an inquiry into what the landlord would have done if the Act were not there. The Act is there, and the landlords formulate their plans accordingly. The relevant question is, given that the landlord's evidence is, I will not carry out the works unless I need to get vacant possession under ground F. The question is, does that satisfy the statutory test? And it's because we say that the statutory test requires the landlord to have decided that it will carry out the redevelopment however it obtains possession, and the landlord has not made that decision here. That's why it's irrelevant, we say, that the prospect of the tenant leaving voluntarily is only theoretical. Because the question is, what is the statutory test? And does the landlord satisfy that test? Say that it doesn't matter if, in fact, the tenant is very keen to stay and unlikely to leave voluntarily. My ladies and my lords, I was now proposing to turn briefly to deal with the motive cases raised by the landlord. In short, our position is that none of them have raised the issues with which this court is now concerned, and they don't provide, therefore, any assistance to your lordships in deciding how this case should be decided. The doctrine of precedent requires that statements made by judges must be seen in the context of the facts of the case before them. A proposition can't be taken out of context and treated as if it's comprehensively addressing every situation which might conceivably arise.
Well, the thing that's binding is the ratio of a case.
The thing that's binding is the ratio of the case, lady.
Which is the combination of the basic facts, the result, and the route to get there.
Indeed, my lady, indeed. So
things that judges say along the way are of great interest, and sometimes of great importance, but they're not binding.
No, my lady, indeed. So you'll have seen that we set out our position on the various cases in Appendix 5. I'm not going to ask you to turn to that, but the reference is Core Bundle 5, page 148. There's one additional case which is cited by the landlord, which doesn't feature in Appendix 5. That's Town Tailors and Peacock Stores, but that simply falls into the same category as Fishers and Tailors and Betty's Cafes. That is to say, it's a case where the court's considering the overlap between ground F and ground G. I was proposing only to take you to the Betty's Cafes decision, since it's at House of Lords level, but if your lordships are happy for me to move on and simply leave it on the basis of the proposition that it doesn't provide binding authority because it doesn't address the issues in this case, I'm happy to move on.
Does anybody want to look at Betty's? No. Very good cafe.
Have you been there?
Not the Bradford
This
one.
is the Bradford
That
one.
was about the Bradford one. I've never been to the Bradford one, of course.
I
Those are the
confess
case.
at a disadvantage in that I haven't been to any of them.
So next, I turn very briefly to this question of reasonableness, sensibleness, good estate management. I'm not proposing to take your lordships to the cases, but as I've explained, it's not our case that the courts must judge the reasonableness or sense of the landlord's proposal in general terms, and it's only where the scheme or items of work within a scheme are wholly lacking in any purpose at all, other than getting the tenant out, that they fail the test of ground F. So we accept it is for the landlord to bring forward the redevelopment proposals it intends to carry out. It is open to the tenant to say either that the obstacles in the landlord's way are so great that the landlord does not objectively intend to carry out those works, doesn't have a reasonable prospect of getting planning permission, for example, or alternatively, that the landlord does not reasonably require possession from the tenant to do the works, for example, because they could be phased in such a way as to take place around the tenant. And that's clearly open to the court in relation to the last part of ground F. But we accept it's not open to the tenant to say the landlord could be doing something completely different, the landlord could be building a different fire station so that I can stay on. But we do say that the corollary of the landlord having the right to say what the works are that it wants to carry out is it must bring forward to the court the entirety of the scheme that it intends to carry out. Otherwise, it is concealing material facts within the provisions of Section 37A. Lastly, I just want to turn to some points made by my learned friends under the heading settled practice and what I call legislative omission, sometimes called tacit legislation. So it's been suggested that ground F should be construed as the landlord contends because either Parliament hasn't taken up the opportunity to amend it, or alternatively that there is some form of settled practice or customary meaning to be given to ground F. On your Lordship's desk in the little pack, you have the case of Newham and Lewisham, which deals with both of these points.
I mean, arguments of that kind are almost always circular because they assume that an amendment is required, and that's the whole issue before us.
Yes, indeed. But I thought it right to take your Lordships to the law, insofar as we have it, about construing statutes by reference to practice or by reference to the fact that Parliament hasn't legislated, so that you have it in mind. And if I can take you first, please, to the judgment of Lord Carnworth at paragraph 76, which is at page 1310 of the report. And Lord Carnworth makes some obiter comments about both of these issues, tacit legislation, that is to say, what Parliament is said to have intended by not legislating, and also what he calls customary meaning. Paragraph 82 on page 1311, he expresses difficulty with the concept of tacit legislation. Parliament legislates by what it says, or what is said under its authority, not by what it does not say. Anything else can only be justified as judge-made law. And over the page, paragraph 85 says, we were referred to no authority which is applied, it's the Barras principle, to a case where the most that can be said is that Parliament has failed to take what might seem an obvious opportunity to legislate. Absence of legislation may be governed by many factors which have nothing to do with the perceived merits. And then paragraph 95, Lord Carnworth says, again obiter, that the case provides an opportunity for this court to confirm that settled practice may in appropriate circumstances be a legitimate aid to statutory interpretation.
But did the court so confirm?
Sorry. No.
No, I didn't think it did.
My lady, it's fair to say everything is obiter on this particular point, but you, my lady, and Lord Newberger gave very powerful, if I may say so, that's not intended to be simply flattery, but very powerful dissenting reasons for disagreeing with this concept. But it is fair to say that Lord Hodge agrees with Lord Carnworth, and I think that makes it a majority. So Lord Hodge, with whom Lord Wilson, Lord Clark and Lord Toulson agreed, deals with it at Sorry. At paragraph 53. That's right, sorry, I did have it marked. Paragraph 53, just towards the end of that paragraph, he says, inferences from parliamentary inaction are more difficult, so agreeing with Lord Carnwath about the legislation by omission. And then he goes on to say, in my view, the settled practice principle of which Lord Carnwath writes is available where there is ambiguity in a statutory provision, but for the reasons set out above, I detect no ambiguity. And he says it does not apply. So we have only, everything is obiter to that extent.
Yes.
And my Lady Hale's absolutely right that there were strong dissenting.
Well, there was a strong dissent on the substance of the decision.
There's a strong dissent on the substance of the decision, but also on the question of customary meaning or settled practice. And we see that in Lord Newburger's judgment, page 1329, paragraph 148. It says he has greater reservations about the so-called customary meaning rule. And at the top of page 1330, says to decide that settled practice gives a statute a meaning which is different from that which the court believes that it has, could be said to be breach of the fundamental duty of the court to give effect to the will of Parliament. And then in paragraph 149, he goes on to say that even if there is a customary meaning rule, it shouldn't apply here. On the question of tacit legislation or legislation by omission, Lord Newburger deals with that at paragraph 143 on page 1328. It's not safe in practice or appropriate in principle to draw the conclusion that the present legislation bindingly assumes sub silentio that the law is as the Court of Appeal had decided. And my Lady Hale deals with this at paragraphs 167 and the top of 168. 167 deals with the question of Parliament passing legislation on the basis that the law stated by the Court of Appeal is correct. And my lady said that comes nowhere near an expression of parliamentary approval of it. Parliament can always legislate to change a decision of the higher court should it wish to, but no conclusions can be drawn from the fact that it has not. And at the start of paragraph 168, my lady said you also shared Lord Newburger's reservations about the so-called customary meaning rule. So, coming out of the Lewisham and Newham case, we have only obiter comments on both legislation by omission and settled practice. But in the subsequent decision of this court in Hotak and Southwark, which your lordships also have in your little pack, paragraph 60, page 837 of the report. Lord Newburger deals with an argument that Parliament had impiedly approved what was said by the Court of Appeal by having made subsequent amendments without in any way amending a particular provision. This is a useful opportunity to emphasise that this is a misconceived argument for the reasons which Baroness Hale and I gave in N and Lewisham, which, albeit in dissenting judgments, represent the law on this topic. And Lord Newburger's judgment was given with the agreement of, I think, all the other Lords, Supreme Court Justices, Lord Clark, Lord Wilson and Lord Hughes.
but possibly not me.
I think not you, my lady.
But I would have agreed with that paragraph.
Yes, I don't. You didn't address this particular point there. So, so we have the position where the suggestion that we can derive the meaning of a statute from Parliament's failure to reverse an earlier decision does not represent the law, and we have obiter comments from this court about the possibility that settled practice of some form might be a guide to how we read an Act of Parliament, but with good reasons for doubting that as a possibility. What we say is that even in relation to settled practice, what is anticipated is where the issue has been authoritatively settled by a lower court. And that hasn't happened here. All that's suggested by the landlord's case is that it suggests that landlords might be beefing up the works that they put before the court under Ground F, and it's not at all clear what exactly it's suggesting the settled practice might be. Are they suggesting that landlords are putting before the court works without any purpose at all, or simply that they are motivated to formulate their schemes by a desire to satisfy Ground F? We simply don't know. And that sort of submission, we say, is absolutely miles away from the sort of settled practice which was under discussion in the Newham and Lewisham case, and which might possibly engage that rule about customary meaning. We say that the landlord is asking you to give a statutory provision of meaning it would not otherwise bear on the basis of an assertion that practitioners have been misreading it. And if practitioners have been misreading Ground F, then we submit this is the opportunity for this court to settle that meaning, and if the practice needs to change, then we say so be it. My lords, ladies, those are my submissions.
Thank you very much indeed, Miss Wicks. Mr. Portman?
My lady.
Mr. Featherstone.
My ladies, my lords. My learned friend took your ladies and lordships to the relevant provisions of the statute at the forefront of her submissions. And my ladies, my lords, I won't go through that again, but can I just leave your ladies and lordships with this comment? It's quite clear that the 1954 Act, in contrast to the 1927 Act, which gave tenants virtually no security of tenure, made a big difference by introducing as a default provision the right for tenants to apply for new tenancies of their business premises unless they had been contracted out. It balanced that new right for tenants with a right for the landlord to oppose the grant of a new tenancy on certain grounds set out in Section 30. And stemming from that, my ladies and my lords, the first point that I make is that the 1954 Act created an interference with the landlord's common law rights. Before it came into force, the landlord had a perfect right to turf out a tenant at the end of the contractual term with unsatisfactory compensation, and only very rarely having to face putting up with the tenant, but even in those cases, being able to get the tenant out if it wanted to redevelop. Now, my ladies, my lords, where there is an interference with common law rights, the principle is that you do not stretch a statute that interferes with those rights further than the meaning of its words allow. And we cite two authorities in support of that proposition. I'm sure your ladies and lordships are well aware of the principle. The one in the House of Lords is Re Wonderland, which was a decision on the 1954 Act itself. And for your ladies and lordships, note it's in Bundle 4, tab 1, page 1969, with the relevant passage between 1982 to 1983, with Viscount Simons saying any ambiguity is to be resolved in favour of the landlord. So, Lord, that's the first point that we make. In any event, we say that there is no ambiguity in this case. 31F is tolerably clear, and with one brief-lived exception, not one of Her Majesty's judges have ever been in any doubt as to its correct interpretation. My Lord, before your Lordships perhaps lose sight of the Lewisham case, which I don't otherwise propose to comment upon, can I just take your Ladies and Lordships to something Lord Newburger said at page 1331, which is useful in this context. He said at paragraph 154, when it comes to relying on policy in a case of statutory interpretation, I would respectfully refer to the observations of Lord Simon and Lord Diplock in Maunsell and Ollins, which, although in a dissenting judgment, were cited with apparent approval by Lord Bingham in the Spath Home case. And this is the quotation: "For a court of construction to constrain statutory language which has a primary natural meaning appropriate to its context, so as to give it an artificial meaning which is appropriate only to remedy the mischief which is conceived to have occasioned the statutory provision, is to proceed unsupported by principle, inconsonant with authority, and oblivious of the actual practice of parliamentary draftsmen." And my ladies, my lords, I'll come back in due course to the problems created by the F plus interpretation, which my learned friend has been canvassing in front of your ladies and lordships. Regarding 31F itself, my ladies and lords, we say, indeed the authorities say, that this ground contains its own express limitations. It applies only where the landlord is intending, and thanks to Lord Asquith, we know what that means. It's to do with mental state and capability. That's largely common ground and does not arise on this appeal. So the landlord is intending to carry out either demolition or substantial works. And to the extent that this ground is said to be open to abuse on the footing that the landlord may just want to get possession and put forward an artificial scheme devoid of any commercial purpose or personal or public benefit, the answers to that are twofold. First, the burden of satisfying the court that that is what the landlord genuinely intends to do is likely to be correspondingly higher in a, quotes, artificial case. And secondly, the landlord will be likely to have to spend a great deal of money preparing for and then carrying out the works. And my ladies and lords, those two factors make it really quite unlikely that schemes from which the landlord is to derive no benefit at all will not be abundant.
Well, that depends, doesn't it, on the location of the property. I'm sure you're right, as applied to areas of outer London, for example, but not necessarily in relation to prime property like Jermyn Street. But the difference in the value of the property without the tenant may very well exceed by a vast margin the cost of the works, especially if the works are of a purely destructive nature.
Yes, my lord, I'll come back in due course, if I may, to the point, especially where the works are purely of destructive nature. In that sort of case, and we had the earlier example of demolition of a building to leave a vacant space without any works then being conducted on the space, presents very real problems about how you apply my learned friend's F plus test. My lord, I'll come back to that. The F plus test, as learned friend originally formulated it below, was that the work should involve buildings and land being improved and modernized so as to be put to their most beneficial and efficient use in the public interest. And there were a number of things that were quite obviously wrong with that. First, it was contrary to virtually all authority on F cases under the 1954 Act. And, my lords, we cite the authorities in our written case. We know from my Lady Hale's judgment in Major Stake, for example, that the works need not be sensible, admittedly in the context of the 1993 Act. We know from an authority called Becker that the works need not be objectively desirable. And we know from other authorities, and Het is the one that we cite, that the works need not be desirable or wise or have long-term viability. And perhaps because of all those considerations, the tenant then changed tack in its appeal and came up with the alternative formulation that the work must be useful or serve a commercial purpose, although I think learned friend may have modified even that test on her feet this morning. So in the light of the authorities, the tenant's case evolved from saying that the works had to be beneficial and in the public interest to saying that the works needn't be reasonable or sensible, and it is irrelevant that the works might provide a building which is recognizably less good than a different or better building scheme. So what is the tenant's contention exactly? Well, the formulation now put forward is that an artificial scheme of works which has no commercial or practical purpose other than allowing it to avoid the tenant's right to a new lease, in other words, a contrived scheme serving no useful or commercial purpose, will not satisfy ground F. Now, my ladies and lords, we say even that formulation does not apply to us for the reason that our scheme does have an ultimate commercial purpose. And I'll come back to that below.
But the commercial purpose of getting the tenant out?
Well, my lord, no. The finding below was that, the evidence in front of the court from the landlord's witness was that the landlord wanted to have 2 retail units available to it. But of course, that wasn't immediately on its horizon. It was something it wanted to construct, having carried out the works of demolition first. But that was down the line. But immediately, my lord, the facilitation of those works would enable it to do that. There were other works in the basement, my lord, which were beneficial on any basis, works of drainage to improve the premises.
Well, her evidence, quoted in the statement of facts and issues, is that the project had no other purpose than to get the tenant out.
Yes, my lord.
I'm not sure you're at liberty to make the submission that you've just made in the face of the judge's findings and the agreed statement of facts.
My lord, there were 2 points that were being made. One was that the purpose was to get the tenant out, but that was not to say that the works had no eventual commercial purpose. My lord, that was in the landlord's witness statement. Now, let us stay with the proposed test of useful or commercial purpose. Staying with that, if the touchstone is usefulness, by what criteria is that to be judged? Useful to the landlord, to the general public? What does useful mean? Can the landlord simply demolish and then leave an empty space? Would that be considered to be useful? And my lords, those questions are real-world questions which it is very difficult to find an answer to. And part of the problem may be that one doesn't know whether the right test to apply is one that's objective or subjective. If it's subjective, presumably the landlord can come forward and say, well, the reason I want to demolish is to leave a vacant space. Taking my Lord Briggs's point from earlier, it might be a barn that's in the view that he wants to demolish, even though the result of all that is that he will no longer achieve a productive income from that space. But it's just something that will satisfy him. But a friend came up with the idea of a folly. We say that is also real world, it's not fanciful. So if the test is subjective, a landlord would presumably come to court and say, it suits my purpose, I've always wanted to have a folly there, perhaps a memorial to my partner, And who's to say that that falls outside the test? If the test is objective, my ladies and lords, then that changes things massively. So to take the example of the demolished barn, how is a court to judge whether purpose is served without hearing evidence from the landlord as to its motive in doing so? And again, that raises real-world problems of formidable complexity. And it's quite unlike the tax avoidance authorities, where the only germane question is the purpose of this rather complicated maneuver simply to avoid tax? That's a very straightforward inquiry with a yes-no answer. But when one tries to apply that to a demolition, Lord, it becomes fantastically complicated. There may be all sorts of reasons why a building is to be demolished. It may be for reasons of procuring a better view. It may be just to abide the event and see what happens with the property market in the future. But all that 31F is clear about is that demolition is one of the grounds under F on which a landlord is entitled to succeed with its ground of opposition. So it's very difficult to see from learned friends' test of usefulness or commerciality whether subjective or objective is one that's to be applied, what the answer would be in any particular case, how a judge in the county court is supposed to deal with it, how the parties are expected to prepare for that.
Well, Miss Pheasant, I wonder if you're tilting at a recently demolished windmill, in the sense that I thought Miss Wicks had more or less got to the position, which quite closely aligns with the ground of appeal, if you leave out predominant, which is that the section isn't satisfied if the only purpose is the removal of the tenant. Though I think she would add, with such other commercial beneficial consequences as might flow from that.
Yes, but my lord, staying with the demolished building example, that's all a landlord needs to show on the state of the authorities at the moment. Does a landlord come to court saying, I'm intending to demolish this building, my motives for doing so are irrelevant? It may be, if pressed, that I might say I would be glad to be rid of this tenant. It may be that I will then be able to enjoy the view. It may be that I can just have a piece of clear land which I might be able to build upon in the future. Now, which of those questions are the right ones to put before the court? And you can only answer that when you know whether the test is objective or subjective. And depending upon that, my lord, it may be phenomenally complicated. If it's an objective test and all the landlord is doing is saying, I just want to get this building out of the way, it's been my aim for a long time, how is a court to assess whether that achieves objectively a purpose? What is the lodestone of that? What's the test? And one thing that my learned friend put forward as a possible guide to assessing the purpose was whether planning permission was obtained or not. And my lord, the availability of planning permission was a factor that was expressly disavowed in the interim report leading up to the 1954 Act. And we've cited the relevant passages in Appendix 1 to our written case.
Well, it may affect the question whether it's feasible to do it, and if it does, whether the intention is genuine.
Yes.
I think that's the point that Lord Justice Asquith was making.
My lord, that's right. But so if the guidelines are not to be judged by reference to whether planning permission is being granted in order to assess whether the purpose is within F, then what is one left with? Which agency is to adjudicate on the question whether the purpose is one that fits within F or not? So the F+ test goes much further than the authorities in coming up with this entirely original add-on that not merely must the works be substantial enough to qualify for F, not merely must they be genuinely intended by the landlord, but they must also serve some other purpose. And I'll develop this in a little while, my lords. And I add in relation to planning permission, of course, this was a case where planning permission was not needed anyway. and that will frequently be the case. Our planning permission, by and large, is needed only where the works are structural or to the exterior, but not where the works are to the interior. And in many cases, the demise will be an eggshell demise. The landlord proposes to remove every single part of the skin of the eggshell. And so planning permission simply won't be a consideration. So, my lords, I'll come back to this, but I do say that under the F+ test, it is extremely difficult to formulate the yardstick that should be applied. Should it be increasing the value of the landlord's reversion, public benefit, general prettification? There are no answers to any of these questions. I think your ladies and lordships were not taken to the pre-legislative materials. I don't propose to do so, given the shortness with which learned friend dealt with the point. It's all set out in Appendix 1 to our written case. My lords, I do stress
Well, we told her
this.
to be short.
I'm so sorry.
We told her to be short.
Yes, and I'm not going to depart from that indication, my lady. But I do make this point. A couple of times, my learned friend referred to the purpose of the Act as being to encourage worthy developments if the landlord was to rely upon F, and to ensure otherwise that tenants had the ability to stay in their premises. My lord, that is not the way in which the pre-1954 Act materials read. I do invite your lordship, should this be a point that commands any support at all, to look to the materials set out in our Appendix 1. So whereas learned friend says, well, it was obvious, drawing upon those materials, that the ground of opposition in 31F would only be used where it was in the interest of good estate management and so on and so forth. That is simply not borne out by the pre-1954 Act materials. Can I develop that point in this way? When Parliament was enacting the 1954 Act, it had a number of good legislative precedents for what F might say. And the very first one was the Increase of Rent and Mortgage Interest Restrictions Act 1920. Indeed, that was one of the acts that was part of the focus of the 1953 White Paper. It wasn't just the business security of tenure, it also looked at Rent Act points. And the formula in that case was to allow a landlord to take back premises where they are bona fide required for the purpose of a scheme of reconstruction or improvement, which appears to the court to be desirable in the public interest. So that, as it were, was a ready packaged F+ test, which could have been used. My lords and ladies, there are others. The 1949 interim report recommended that the landlord should be required to satisfy the tribunal that the premises were reasonably required for such a scheme, and that qualifier does not appear in 31F. There were others, my lords and ladies. The interim committee opined that there could be a provision saying that possession could only be recovered where to do so was in the public interest. But again, there was no positive recommendation to that effect. And so on and so forth. The 1951 Act, the Temporary Provisions Act, which came in to hold the gap just before the 1954 Act, said that the court should not order a new tenancy if the landlord reasonably required possession. But again, we find no reflection of that in 31F itself. So the legislative history provides no support at all for my learned friend's approach to the F+ test. And my ladies and lords, neither do the authorities, and again I detected from my Lady Hale perhaps an unwillingness to be drawn too closely into decisions which are largely of the Court of Appeal. And my lady, I will follow that, what I took to be that indication.
Not sure where you got that from.
Well, I think only invited my learned friend perhaps not to press the point on the authorities too firmly. But if I may...
I think that was addressed to obiter dicta in the authorities and not to the particular status of the court deciding it.
Absolutely.
Can I then take my ladies and my lords to Fisher, which is in the first bundle behind tab 6, starting at page 585. So a decision of the Court of Appeal from 1956, so 2 years after the passage into law of the 1954 Act. And can I just go very briefly to the facts and the head note? The landlords of a retail shop who purchased the premises within the preceding 5 years gave notice to the tenant terminating his tenancy. The tenant applied to court for the grant of a new tenancy, and the landlords opposed on ground F. It was proved to the satisfaction of the judge that the landlords intended to demolish the whole of the premises. They couldn't reasonably do so without obtaining possession, and their object was not to occupy the old building, but to rebuild on the site and to occupy the new building for the purposes of their business of furniture retailers. So that was the factual background. And then can I take your lordships and ladyships to page 590, where Lord Justice Denning's judgment appears. He says in the last 2 lines on that page, 590, we have to consider the decision of this court in Atkinson and Bettison. I'm sorry to find that that decision has given rise to difficulties. Inasmuch as I was a party to it, I should like to explain it. The correct ground of the decision was that the proposed work was not substantial within 31F, but the court considered also 31G and 2, which says that if the landlord wants to get possession, he must have been owner for the last 5 years. In this connection, the court gave an emphatic warning against allowing a landlord too easily to escape from the 5 years rule. That's the full extent of Atkinson and Bettison. My ladies and lords, then going down to pretty much halfway down the page, a few lines into the next paragraph. So he puts forward a case, this is the notional landlord, he puts forward a case for reconstruction under F, hoping to get possession on that ground. In such circumstances, the court must be careful to see that 31F is fully satisfied before it allows him to get possession. For this purpose, the court must be satisfied that the intention to reconstruct is genuine and not colourable, that it's a firm and settled intention not likely to be changed, that the reconstruction is a substantial part of the premises, indeed so substantial that it cannot be thought to be a device to get possession, that the work is so extensive that it's necessary to get possession of the holding in order to do it, and that it is intended to do the work at once and not after a time. Unless the court were to insist strictly on these requirements, tenants might be deprived of the protection which Parliament intended them to have. It must be remembered that if the landlord, having got possession, honestly changes his mind and does not do any work of reconstruction, the tenant has no remedy. Hence the necessity for a firm and settled intention. It must also be remembered that the Act is intended for the protection of shopkeepers, and that this protection would be nullified if a big concern could buy the property and get possession by putting in, say, a new shop front. Hence the necessity for the work being substantial. So, my ladies and lords, Lord Denning plainly has in mind possible abuses of the 54 Act, and in particular ground F, and his rejoinder to the 2 anxieties is, well, it must be a firm and settled intention for the landlord to have, and the work must be substantial, nothing else. Lord Justice Morris, if I can go to...
He seems to have thought that the importance of ruling out devices to get possession was always going to be satisfied by the expense occasioned by substantial works. I mean, that might have been true, I suppose, in when are we talking about, 1956? But I wonder if it's, as Lord Sumption said in relation to Jermyn Street, a reliable assumption, if that's the objective.
Well, my lord, it was the statutory objective in 1954, Your Lordship's point may call for an amendment of the 1954 Act.
Well, I was thinking more of a possible amendment to Lord Denning's reasoning.
Well,
Or development of it. Development.
Yes. Or reconstruction of it.
But not demolition.
No.
Yes, one always has to bear in mind, my lords, that these separate grounds are all quite distinct. So demolition alone will satisfy the test, irrespective of the cost. And that's still the case. It's very difficult to see how one can revise that today. That wouldn't mean a development to Lord Denning's thinking. It would mean a statutory amendment if one is to say that demolition must be limited in some way because the balance between the price of doing building work and the value to be obtained from getting vacant possession has just become out of kilter. Can I just take your lordships, before leaving this case, briefly to the two other judgments? There's Lord Justice Morris, and part of his judgment, which is relevant, is at the top of page 594. First line, Mr. Sterling, that's counsel for the tenant, submits two reasons. In the first place, he submits that a landlord can only succeed in his opposition under Section 31F if the proposed works owe their planning and inception to the dictates of sound estate management, or stated otherwise, that viewed in detachment and unrelated to any intention to occupy, the landlord has the objective aim of protecting the asset of which he is owner. And he concludes, I do not find in the section any wording which warrants these submissions. And then at 596, another passage from Lord Justice Morris's judgment. Last few lines on the page, beginning with the word considerations. He says, considerations as to what may be a landlord's primary purpose, or his real intention, or his main purpose, or his secondary purpose, or his real reason, are only of relevance and assistance in the course of deciding whether the landlord has proved that he genuinely has an intention of doing one of the things specified in 31F, and of doing it on the termination of the current tenancy. If the landlord proves his intentions and proves them to the satisfaction of the court, and proves that in order to carry them out he must have possession of the holding, then his opposition succeeds, and it matters not that after demolition or reconstruction or construction, according to his proved intention, he proposes himself to be in occupation. In the next paragraph, if a case occurs in which it appears the landlord had a desire to obtain possession for his own occupation and had no thought at all of making any alteration to the premises, but if, after realizing that because he hadn't owned for 5 years, he couldn't oppose an application of his tenant for a new lease, he then proclaimed an intention to reconstruct, the court would have to decide whether the newly proclaimed intention was genuine. It certainly could be entirely genuine, even though it owed its birth to a realization of the effect of Section 32 upon a desire and intention coming within Section 31G, but the circumstances would call for careful examination. Intentions can easily be asserted, their genuineness must be established. In such examination, the only inquiry would be and must be as to whether the landlord had proved an intention which brings him within the language of 31F. Then, if I may conclude with Lord Justice Parker, over leaf, page 598, about 2/3 of the way down, he says, thus, if ground F is proved to the satisfaction of the court, it matters not to what use the landlord ultimately intends to put the holding. He may intend to let it when the work is done to a third party. He may intend ultimately to occupy it himself for his own business, or he may not have made up his mind at all. To suggest that, if his intention is ultimately to occupy it himself, and he cannot, by reason of subsection 2 of section 30, rely on ground G, he is thereby debarred from relying on ground F, is to apply a proviso to the operation of ground F which is not there, and for which there is no warrant. Of course, if he finds himself debarred from relying on ground G and is forced to rely on ground F, his task will not be an easy one. It will at once be suspected that his alleged intention is not genuine, and that it is merely put forward to circumvent his ability to rely on ground G. But assuming that he satisfied the court that the intention is genuine, I see no reason why he should be debarred from relying on ground F. And then if I can skip to the middle of the page, Mr. Sterling, however, urged for the tenant that in order to rely on ground F, the landlord must show that his intention to do the work is based on principles of good business management or sound economics. Again, I can see no warrant for introducing any such implied limitation on the express words of the paragraph. No doubt if a landlord alleged an intention to pull down perfectly good and perfectly sound and useful buildings, that intention would be suspect and make it harder for him to establish the genuineness of his alleged intention. But it's another thing to say that however genuine his intention, he cannot succeed unless he can show that the proposed work is consistent with good business management. So that's a very early example, my lords and ladies, of the court looking at an interesting case where the landlord quite clearly, because he was in the first 5 years after purchase, couldn't rely upon G, but that was really his ulterior motive, if I can put it that way, which was to occupy himself. And in the end came up with a 31F ground of opposition, but proved it to the satisfaction of the court. And in that case, the court approached 31F solely on the basis that there were just the two ingredients to satisfy the substantiality of the works and the genuineness of the intention. And despite the fact that these were cases where it was being said that that was all artificial, because the real motive was just to get the premises back for the landlord's own occupation, the court said, well, that's just not material. We have to look at what the landlord's actually going to do. And as Lord Justice Parker said, it doesn't matter that the landlord, having demolished, might not actually have a use for the premises in mind. The only material question for 31F is, does he intend to do the works? Not why does he intend to do them. That's simply irrelevant. My lords and ladies, I won't take up time by referring to other like authorities, because they simply make the same points, that it's not the interests of the public that are material,
well, I think
weighing up
Mr.
30.
Wicks has accepted that.
Yes, yes.
Indeed, I think much of what you've been saying is aiming at a much larger target than Ms. Wicks has actually presented to you.
Thank you, my lord. Can I turn then to workability? And I've already made some references to this. And this is the point that we advance. If my learned friend is right about purpose forming part of the test, even though not expressed in 31F, how does one formulate a test which might be said to encapsulate the parliamentary intention? And the examples of the problems that we give in our written case are many and various. One can think of, and none of these are particularly fanciful, what about the Turner Prize-winning landlord who wants to put very big rusty iron girders all over the interior of the demised premises so as to make them incapable of occupation? How is that to be assessed? The landlord would say, well, that's all I want to do. I can see it's slightly eccentric, but I just want a standing exhibition to this sculptor that I admire particularly. Is that to be within the F+ test? What about the landlord who simply wishes to demolish and then leave his premises vacant, either to minimize tax or rates, or to await a comprehensive redevelopment scheme involving adjacent premises? And to a certain extent, my ladies and lords, we say that is the case here. In due case, it was the evidence accepted below, the landlord wishes to carry out a comprehensive redevelopment scheme, and it wants these premises to be vacant at the time so as to have a smooth ride. What about, my ladies and lords, the landlord who thinks it has a good 31F case, but who is advised to put it beyond doubt by augmenting it with further works which it would not otherwise have done in which the good works are subsumed. How is the court to approach that sort of case? What about the landlord who just wants to flatten the premises just to make sure? How does one approach that? And my ladies and lords, what's the difference between another landlord in our shoes who might have put forward exactly the same scheme, but just as a matter of personal idiosyncrasy, and us, who've carried out the works, and we were completely transparent about this, in order to clear the decks for its eventual overall scheme? So we cannot see, my ladies and lords, that it's possible to formulate a meaningful test that distinguishes between those various problematic examples that I've just described to your ladyships and lordships. And the courts have shown the same reluctance to engage with such matters. I've already taken your ladies and lordships to Fisher. I'd like to pick up another one which bears on this topic, which is Decca Navigator, again in the first bundle, behind tab 5. Page 577. This is yet another authority in which Lord Denning, then Lord Denning, Master of the Rolls, appeared in the Court of Appeal. But it's the judgment of Lord Justice Cairns that I'd like to take your ladyships and lordships to. At page 581. So he says, right at the forefront of his judgment, a tenant can get a new lease of part of the holding under section 31A 1B if the court is satisfied that possession of the remainder of the holding would be reasonably sufficient to enable the landlord to carry out the intended work. I can see no warrant for reading this to mean that the court must be satisfied that it is reasonable for the landlord to execute the intended work. Still less can I see any warrant for requiring the court to balance the advantages to the landlord of executing the intended work against any disadvantages to the tenant or any disadvantages to the public of the work being executed. I reach these conclusions on the ground that the construction which we are asked on behalf of the tenant to adopt is one which the words of the section will not bear. But if by some straining of the language one could find the suggested meaning in it, I should be quite unwilling to perform that exercise. For one thing, the court would be required to make an investigation for which it is quite unfitted. The considerations on one side and the other are very often what might be called planning considerations. Such questions as, for instance, whether it is more important for these tenants to be able to find parking space for their employees' cars than for the fire brigade to have plenty of room for manoeuvre, and so on, are quite unsuitable for judicial decision, and so on. So again, the focus, as in the last authority that I showed your ladyships and lordships, is purely on the identified ingredients in F and nothing else. And can I, before leaving that authority, just go to the way Lord Denning expressed himself at page 580, in the middle of the page. He said the county court judge put it well when he said the words "the intended work" in section 31A mean the work which the landlord in fact intends to do, and leave no room for a tenant to argue or the court to decide that it would be in his interests or the interests of the tenant or the interests of the public generally, or that it would be sensible for him to achieve his purpose by doing some different work. And my ladies and lords, I read that as encompassing a case where the landlord doesn't have any particular ulterior motive in doing the works other than just to get rid of the tenant. That's not a permissible line of inquiry for the court. All the landlord has to show that is that it intends to do the works and that they are sufficiently substantial. So I think, my ladies and my lords, I'm making a solid practical point about the burden that would be foisted upon the county courts were they in the future invited to consider not merely intention and substantiality, but also purpose. That is not something that any court, other than the ones below in this case, have ever been invited to do in the whole long history of the 1954 Act. As I've said repeatedly, it's very difficult to see what criteria, in the absence of any indication in 31F itself, the court would apply in weighing up the question. My ladies and lords, I was going to go on to artificiality, and I don't know whether now is a convenient moment.
Well, if you would prefer to leave it until 2 o'clock, we're very happy for you to do so.
Very much obliged.
The court will now adjourn.